The first topic we'll discuss is civil law in Italy. Then we'll move to the definition of a contract, followed by the 4 essential elements. Next, we'll talk about some risk factors involved in doing business. Then we'll talk about courts or forums. And finally, some sustainability issues. Contracts adhere to civil law in Italy. The Italian Civil Code of 1942 gives a general set of rules that apply to all contracts or agreements. Although many of these rules have been thoroughly amended since the last World War. Many certain types of contracts are found in single sections of the Civil Code. Some of these certain contracts include leases over 9 years, building agreements, marriage agreements, sales and purchase contracts, professional service contracts, banking contracts, and many more. Basically, modern contract law is statutory law in Italy. The definition of a contract, as defined by the Italian Civil Code, is an agreement of 2 or more parties to establish, regulate, or extinguish a patrimonial legal relationship among themselves. A patrimonial relationship being one in which only rights and duties may be appreciated in terms of money. Thus, the definition of money is property that belongs to an individual or partnership that compensates for the offeree or the offeror's patrimony. Therefore, contracts may only regard deals that in some way are appreciable in terms of money. Italian law gives 4 essential elements that must be present in order for an agreement to form into a contract. The first element says there must be a mutual agreement that is understood by both parties. The second condition implies the agreement must be sufficient enough to justify legal protection under the law. The third element protects from unreasonable and unlawful objects that may be contained in a contract. Any unlawful object, it's obviously deemed void. The certain and discernible parts aim to avoid vague or inconsistent terms in a contract. In this instance, the word discernible means whenever the parties have at least agreed upon the method to define the contract. The fourth and final condition is similar to the last essential element found in U.S. contract law. So in Italy, the general rule is that informal contracts are valid, but some certain contracts must be in writing and notarized to be deemed binding. Along with the risk listed, Italy is currently in the middle of their worst recession since 1975. Italians currently face some of the same financial problems as Americans do. One negative characteristic the Italian and American governments have in common is massive public debt. The Italian government is restraining from using any major fiscal stimulus package to boost the economy. Minister of the Economy Julio Tremonti says that even though other countries may be able to increase deficit and debt levels, Italy cannot. He is not convinced that more government spending is a good fix anyway. Tremonti also has fears of a hike in borrowing cost and a spread in interest rates, which would substantially raise their public debt if a major fiscal stimulus move was made. The major downside to executing contracts in Italy is their crawling judicial system. The average time between an indictment and a verdict is 10 years. Therefore, recovery in a case of a breach or a fraud could be hopeless. Even though it's not on the slide, I'm going to talk a little bit about tort law and violations of contracts. 2 key differences in legal procedure distinguish tort laws from breaches. Tort law requires the plaintiff to prove that the damages were caused by the other party. Contract law requires that the defendant prove failure to perform the agreement was not their fault. Tort law allows for total recovery of any damages suffered, whereas contract law only allows for plaintiffs to recover damages that could have reasonably been foreseen at the time of the agreement. The Italian court system plays a major role in shaping statutory laws in the field of contracts. Previous court hearings and decisions are published via periodicals, journals, and CDs, along with commentaries. These prior cases are often cited by lawyers in their claims and petitions as having effective verdicts. So in reality, even though case law is not legally binding, it has a major impact on the outcome of cases. Some good news is the Italian banking system seems to be in solid shape, mainly because they banked on more sound, lower risk credit tools than did the UK and the US. Tourism is also another plus for Italy, where they still maintain an edge on other destinations around the world. Italy's strong entrepreneurial sector is expected to continue to generate positive growth in the coming years. Along with the productivity and thriftiness of the private sector, a sound banking system should ultimately squeeze the Italians through this recession.